Welcome to Just Minding My Business. I hope you're having an amazing day. And I am so happy to bring to Just Minding My Business today Gary Matossio, who throughout his legal career has focused exclusively on representing employees against employers. Gary has earned a reputation for his commitment to advocating for workers' rights and securing justice for his clients. Gary's practice spans both in state and federal court, as well as before the Equal Employment Opportunity Commission, which is EEOC, and equivalent state agencies. With a keen understanding of employment law, he navigates complex legal landscapes to ensure that employees receive the representation they deserve. Welcome, Gary.
Thank you so much for having me. I really appreciate it.
Yes, yes. So let me just ask you, what made you go into employment law?
That's a good question. I knew I wanted to be on the plaintiff side, which is typically the one bringing the claim, the little guy, so to speak. I didn't know what exact area I wanted to get into, but basically when I got out of law school 13 years ago, I was looking around for jobs on the plaintiff side, and first one that I got offered was in employment law, and it was a plaintiff's employment law firm, and worked with that firm for about 12 years before starting my own firm last year. So it's been great. It's all I've ever done. It's all I know, and it's a really challenging and rewarding area of law, that's for sure.
Yes, indeed, because one of the things that most of these companies have is that at will, where they can get rid of you. I guess if you don't look right that day to them, bye. So how
Right.
do you get around that?
Yeah, that's a good question. So almost every state in the country is at will. So at will employment means you can get fired for good reason, bad reason, no reason, any reason. But that doesn't mean that you're without rights. Employees still do have rights. There's three main buckets that I tell people this is where your rights are going to come from. There's anti-discrimination laws in the workplace, so you cannot be discriminated against for being a member of a protected class. That covers race, age, gender, disability, religion, national origin, sexual orientation, a couple others. So that's the first bucket. Then you're going to have your anti-retaliation statute. So if you complain about being discriminated against based on one of those protected categories, you are free from retaliation. So if an employer wants to terminate you because you raised what's called a protected complaint, you have rights there. And then you're going to have your medical and pregnancy related leave statutes. So you cannot be retaliated against if you take time off due to medical issues under what's called the Family and Medical Leave Act. There are certain requirements as far as time you have to work with an employer and the amount of employees that an employer has to be eligible for the Family and Medical Leave Act. But that offers some protection for employees dealing with medical issues. FMLA also covers paternity and maternity leave. So if you or your spouse is delivering a baby, you have get up to 12 weeks off to handle that. So there's, that's I guess a very high level, outline of exceptions to at will employment. Um, Also in that medical related bucket, you have ADA accommodations. Employers have to work with you to grant reasonable accommodations, and if they don't, then they're in violation of the law and they can't retaliate against you for requesting accommodation. So those are the main buckets where you can have exceptions to at will employment. And I think a lot of employers make mistakes thinking, oh, we can do whatever we want, but they don't realize that there are exceptions. It's not the total wild, wild west. While yes, employers, um, so to speak, can fire for any reason, good reason, bad reason, no reason. It can't be a discriminatory or retaliatory one based on one of those buckets that I just touched on. So, yeah, that's a long, long way to go about answering your question. Is at will employment does not mean you're without rights.
Yes, yes, because it's so much going on in the job, and they kind of like discriminate not directly but indirectly.
Right, right. That's the hardest part. Even if you do have a claim that falls under one of those categories, is proving it, right? The burden of proof lies with us as the employee, as the plaintiff. And yeah, most employers aren't dumb enough to come out and say, I'm firing you because you're a female or because of your specific race, right? No one's um, that dumb, so to speak, right? Um, Another category we deal with is sexual harassment. I think I forgot that out of the last deal, but um, that is one category that made me just think of that. Where yeah, sometimes you do see some very dumb text messages, sexually explicit stuff like that. But aside from my sexual harassment cases, it's rare that we have a smoking gun, absolute in writing proof that the employer is discriminating. So it's on us to prove that, and you prove that, circumstantially, by comparing your treatment to other employees of other different protected classes, things of that nature. Employers not implementing their policies across the board to employees of different races or genders or whatever the claim may be. So there are ways to go about proving it, but it's not easy. You're absolutely right.
Okay, so if you find yourself in a position where you feel as though your company is being discriminatory towards you, what are the things that an employee should do to prepare for the fight?
Right. You should absolutely document your concerns, especially if it's getting to the point where you believe that you're likely going to have to take legal action down the road. You want to have documentation. You want to go to either human resources or upper management, depending on whatever the proper channels that are within your company. And you want to say, I believe I'm being discriminated against based on X. And you want to be unequivocal about that. A lot of people will complain and they'll be on the right track, but then they'll be a little afraid to actually say what's going on, right? You want to put that employer on notice, because the first thing the employer is going to do is say, well, we didn't know. This may have been a one-off. This may have been their colleague. They're not an executive. They're not making decisions, right? You want to put them on notice. And even in situations where the employer does know, they're still going to deny it unless you have it in writing. So you definitely want to send an email, outline your concerns, and then that way you're protected if the employer does retaliate or continue to discriminate against you.
Yes, and a lot of people, I think there's a lot of fear because once you open that can of worms, then they begin to nitpick, so to speak, on everything that you do.
Right. Right.
And how do you work and that's stressful because as humans, if we count how many times we make a mistake in one day, it's definitely over 100 times.
Right. Right. Exactly. Yeah, the nitpicking is something that happens, and that's something that we use to prove up our cases, because we say, "Hey, you're not doing this to my colleague who's made more mistakes, or you're not scrutinizing everyone on my team's work, right?" So, yeah, I know I get it can be very stressful and it's difficult, but I think if it's got to the point where you actually are feeling the discrimination or retaliation, I mean, don't think going and raising a formal complaint is going to make it worse. And if you don't do that, then you're kind of a fish out of water. If you're terminated and bringing up concerns for the first time upon termination, that's not great for a case. We can still work with it. There, like you said, there's still ways to prove it as far as the differential treatment, nitpicking, and things like that. But um, it's much more difficult if you're raising the concerns for the first time during or after your termination.
Yes, yes, indeed. So, what are some of the actual rights in the workplace that an employee has?
Right. So those buckets that I touched on, the specific laws that we're looking at are Title VII. That's going to cover a lot of the anti-discrimination statutes, and then cover the statutes where they say you cannot be retaliated against if you complain about discrimination. You have the Age Discrimination in Employment Act, covers age-related discrimination. That's separate than Title VII. Then you're going to have the ADA, Americans with Disabilities Act, prevents discrimination based on disability, covers accommodations related to medical conditions, and a host of other things. The ADA is a pretty broad act, but in employment scope, you're looking at accommodation related issues, mostly Family Medical Leave Act, the FMLA. Sexual harassment is actually covered by Title VII as well. So those are the protections that you have mostly. It's surrounding discrimination, retaliation, medical and pregnancy related leaves, disability accommodations, and sexual harassment. Those are the protections that you're going to have. But unfortunately, just mean treatment in the workplace, even hostile. You hear the word hostile work environment. It's not necessarily legal unless it's hostile based on one of those categories that I just mentioned. So just general cruel, harsh, and unfair treatment um, is not illegal unless it hits on one of those categories that I touched on.
Now, in terms of discrimination, okay, I mean, as a Black female, I worked in the IT industry for over 50 years. And being number one, there wasn't many women in the field to start with, and definitely not as many Black women in the field to start with. So, I mean, early on in my career, it was a situation where um, it was on the job training kind of thing. If you showed aptitude, then they would, work with you. And I really didn't see it until things started to change where they required a college degree. Even though I knew the job, I found myself in a situation where I was training college students. So is that considered? I don't know how you would, because a lot of things that happen in the workplace don't necessarily fall in those groups,
Mhm.
but
Right.
it's discrimination.
Right. On its face, I mean, situation it may be difficult to show that it's unlawful, but look, the failure to advance you or failure to promote you if you're qualified and promoting others that are less qualified than you, that could give rise to a claim as well. So it doesn't always have to be a termination. Um, you know, if you were the only one being asked to do those things and you had the same qualifications as your peers who were not African American or male, then yeah, then we can kind of use what's called disparate treatment. That would be the angle that I would look at. Um, but yes, there would have to be some element of discrimination based on sex or race in that situation. And yeah, I'm sure you could probably think of a million examples to how you were treated differently,
Oh
especially
yeah,
if you're
when
the
you
only
in
one
it,
breaking.
when
Right,
you in it, you see it like
right,
this day.
right. Absolutely, and it absolutely exists. And sometimes it's blatant, and sometimes you don't. Maybe the bad actor doesn't even realize they're doing it. It's just like an inherent bias, right? But still just as unlawful, as if they're intentionally doing it.
Yeah, and then in other situations, I actually brought it up to my manager about
Right,
it, and of course, nothing was done. I became the person that's complaining. You know what I mean?
right. Yeah, and you did the right thing there by raising concerns, so that you were retaliated against based on that. That would be illegal. But yes, you're right. It's tough. It's a tough spot to be in, knowing when to raise concerns, how to raise concerns. But yeah, it's difficult. But yeah, I mean, sounds like you could have had a case. The statute of
Uh,
limitations probably expired by now, and you're in a great spot. So I don't know.
yeah, I
Absolutely.
could have had a case from a lot of companies. As a matter of fact, I'm going to say this because I'm talking to somebody that probably could have helped me. But I worked for a job for 16 years that I was overqualified for, never got promoted.
Right.
And then one day I got fired because what did they tell me? Something about I was forging my timesheet. When in fact, I would get up and not even get paid for it and set
Hmm.
up my day before working hours.
Right.
People, I mean, I do IT, so people would be calling me. I'd be in a car on my way home from work, and people would be calling me on my cell phone. Can you help me do this? I'm not even on the clock, but I'm
Right.
still helping people.
Yeah, that's interesting. It's yeah, definitely something where we probably could have helped. And when um you made me think of something when you were saying they made up that reason, that like
Yeah,
fabricated
it was a
reason.
lot. It was
We
fat.
call that a pretext. that's what we have to prove typically, because an employer is never going to admit that they discriminated against or retaliated against, like I said, and they're always going to assert what's called a legitimate business reason. That's the way the employer defends the case. Hey, this was not discriminatory. This was our reason, and then we say no, this is why that was BS, and that's making the pretext argument. So that's what we would have done in that situation. We would have shown them all the work you were doing off the clock. And the employer may have said, whoa, 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 this is opening up a whole new can of worms now. That's they probably would have settled that case, right? Because now we're talking wage and hour violations and whatnot. So yeah,
And I would have
that's
had
interesting.
tons of character witnesses because I had people that didn't even want to work with nobody else but me.
Right,
You
right.
know,
Yeah,
so I had plenty of character witnesses, but I didn't pursue it because I didn't want them in my spirit because
I agree.
for a
Yeah.
year, 2 years,
A
you
lot of
know,
people, yeah, a lot of my clients say that, they do feel a weight lifted off their shoulders when the case is over. Hopefully it's a positive result. But yeah, I hear that from a lot of folks. How good it feels to close that chapter. And yeah, the good part about bringing a claim through our firm, there's not that much work you have to do at the beginning. You have to help us collect all the information and documents that we need. You may have to sign a couple things here and there, such as an EEOC charge. Otherwise, it's just kind of let us do the work, and we'll let you know when we have something to report to you. So, yeah, I get it. It's a tolling situation going through a legal claim. We try to make it as stress-free as possible.
well, that's good to know because that was my next question. What kind of information do you need where you can just take the rim and just
Right,
handle the situation? So you
right.
just answered that question. So if employees want to work with you, how do they get in touch with you?
Yeah, so our website is martossiofirm.com, Martoccio firm.com. It has a couple different options how we can evaluate your potential case. You can either call us directly, our number's on the website there, or there's an online case evaluation form that is it's a dynamic form based on how you answer questions. It leads to other questions, and then from there, whether you call in and go through our intake process on the phone or do it online, we would review the situation and let you know if we could be of assistance, and take it from there. And then once you would retain us, we would obviously do a deeper dive into the case and get all the information and documents that we need. You wouldn't have to send us all that at once. We just need some general information to understand if we can help or not.
Oh, okay. So your track record, can we talk a little bit about that?
Sure, sure. Yeah. So yeah, I've been practicing, like I said, almost 13 years now. I've had, I think I'm right at 300 federal lawsuits that I've litigated. So, um, a lot of cases you can resolve early on in the process, and that's the hope and the goal. Sometimes, uh, it doesn't play out that way. It takes the other party to reach a resolution. And while it's usually in an employer's best interest to try to settle, some of them, you know, don't for whatever reason, and we have to push the cases forward into a lawsuit. So, we've had a lot of success resolving matters short of suits being filed. The ones that we've had to file suit on, the vast majority have had successful results. We're kind of looking at, I think, approaching 60 million recovered for plaintiffs over the years now. I think our website says 50. That's getting close to 60 now. And yeah, it's been a really fun and rewarding process to try to help people get in a better position than they would be without you. They're never gonna. I don't think it's ever going to be something where you're made whole and account for every single thing that you lost, monetarily, physically, emotionally. But we hope that we can help everyone move forward, and put them in a better position, as they close that chapter, from being wronged by the employer. So yeah, it's been great. Obviously, look, there are no guarantees. Not every case is a successful one. There's no such thing as a slam dunk, but the vast majority of the cases we handle, we're able to reach a successful resolution.
Oh, well, that's good to hear because most people, it's a very stressful situation because that's your
Absolutely.
livelihood. You pay your bills with this company and they're not treating you right.
Right.
So it's stuff that you take home every day to your family. you always, so and so did this today, so and so did that today. So it gets very, very stressful. And I guess working with an attorney that could ease that emotional side of that.
Right,
Is
right. Yeah, we try to help with that. We try, as the case goes on and a client seeing the defenses that employer is raising, it gets personal, it gets emotional. We try to take that emotion out of it, help them get through that. We, as an attorney, you see a lot of these cases, and while yes, you're fighting your tail off for your client, you can try to help them take the emotion out of it and look at this black and white, dollars and cents wise. And I think a lot of people appreciate that. And they're just helping them move on. It's more than just about the money, right? It's about seeing justice and seeing and move on to that next chapter. Like I said, I can't stress enough that most people just want to close that book and move on and do so in a successful way. And, we're lucky enough to be able
absolutely.
to do that over the years for a lot of people.
And not only that, it also puts the company in check for the next person as well. Because if you go through with that and they don't know that slash, okay, we had somebody sue us, this could happen again. So we need to definitely work on
Right. If
etiquette.
no
So
one brought a claim, there'd be no reason for a company to change. So it certainly does have that effect, and a lot of people, like being a part of that as well.
yes, yes, indeed. Because we have to speak up. Because if we don't, in my case, I didn't, but what happened ended up being a blessing in disguise for me.
Did you a favor, huh?
Yeah, they actually did me a favor because you know how it is. Sometimes you need to move, but you don't move.
Right.
So God
Right.
has to step in and say, let me just move this child because she is definitely not doing it.
Right. Right.
So it turned out to be a blessing in disguise for me.
Oh,
Now,
that's good.
what do you see with future employment law? What do you think is going to happen?
A lot of the laws that touch on employment laws, they've been in place for a while. The Title VII going back to the 60s. You got like the ADA and the FMLA going back to the early 90s. So I don't foresee those laws changing much one way or the other. It will be interesting to see what happens in the employment law world, as a lot of companies are using AI, and there's going to be, I think the workforce is going to see some major changes, as far as the amount of jobs, type of jobs. So that is one thing that I'm keeping an eye on, seeing the impact of that in the workplace. I don't see that there's going to be many changes to laws, honestly. I think it's going to kind of be status quo with that, hoping that there are longstanding laws that are, um, they're statutes that are very difficult to change. You can see some expansions. Like recently, there was something called the Pregnant Workers Fairness Act that expanded on some of the pregnancy-related protections of the standing laws. So you're getting certain things here and there to help advance the current laws, but I think just the principles are probably going to remain status quo. But yeah, I'm very interested on the impact of AI on what we do. Certainly something we're monitoring.
Yes, yes, and that's definitely something to watch because, a lot of people say that it's not going to affect workers, but it is going to affect workers in some way, because it just is. Because companies are all about the bottom line,
Mhm.
speed, efficiency,
Right.
things like
Right.
that. So it's definitely going to affect employees. But
Right.
what I'm hoping for is that, people will be able to use AI as a tool to assist the employee, not to
Right.
replace.
And it can be. Absolutely.
Because at the end of the day, AI ain't gonna buy nothing. It's
Yeah,
it's gonna
that's
be
for sure.
people.
Right. You definitely still need people. We're seeing it as attorneys. It's changing the game, but there's always going to be a need for litigators, negotiators, those. facing, I guess what you call an adversarial position, um, you're going to need an attorney. Clients want to talk to attorneys, but there's a lot of work behind the scenes that AI can help with, and
Oh yeah.
even our own law firm, we've been using it to help some things behind the scenes. It can be used as a tool. So yeah, it's gonna be interesting for sure.
So let me just ask you, what was one of your most difficult cases that you won that you were able to be successful with?
Oh yeah, there's so many come to mind. Probably, when you're talking difficult, that means there's probably one that went into a federal lawsuit. Um, we it's across the board. I will say that probably the most rewarding one was a class action that we did. Um, for workers in Illinois at a factory that closed down. There was a violation of something called the WARN Act. It wasn't one of the laws I talked about before. This is a law that rarely comes into play. Honestly, it's if a factory of a certain size is shutting down, um, employees are owed either 60 days of pay or 60 days of advance notice that the factory is going to shut down. And these employees received the notice, but a week later, doors were closed. They didn't get paychecks. I believe, if I remember right, it was right around the holidays. It was a very troubling time for them to
Mhm.
just have the doors closed. And, they thought they had 60 days, which is what the law said. We brought a case on behalf of those workers, and there are exceptions to that law, and the employer tried to use those exceptions as a defense. And we eventually were able to get a fair settlement for those folks. It was a class action claim, and that's probably the most memorable. Just because you're able to help so many people, being that it was a class, it was an entire workforce.
Yeah, so wow. And I mean, we see that going on right now.
Right,
People
right,
closing their doors and
right,
just
right, right, right.
people just come to work the next day and it's locks on the door.
Yeah,
Notice
that's
and nothing.
that's exactly what happened in this case. That the people were locked out, no notice. Well, they got they were told we will be closing in 60 days. We're complying with the WARN Act, and then I forgot, it was like 5 or 7 days later, locks on the door. So they were owed like whatever 50 some days worth of pay still.
Wow.
Yeah,
That's terrible.
yeah,
Wow, that is so again, how do people connect with you, employees connect so that if they have
right.
issues?
Yep. So I'll give that. I didn't give the phone number before. It's 888-415-7670. That's how we can do a case evaluation over the phone, or you can visit our website. And I won't repeat it. It was a long name. MartoccioFirm.com. You can click on there for a free case evaluation. There's a link on the main page of our website, and you can fill out the form online if you prefer that to calling us. Yeah, my direct email is Gary@MartoccioFirm.com. um, Feel free to email me directly, and I can send you in the right direction as far as the case evaluation may be concerned.
Hey, so what states do you practice in?
Yeah, that's a good question. So 9 states: Florida, Illinois, Massachusetts, Arizona, North Carolina, Texas, Tennessee, Pennsylvania, and Georgia. Yep, that's 9.
Okay, okay. Wow, so you got a pretty broad territory.
Yes, absolutely. And if it's in a state that we don't practice in, we sometimes get calls. Um, People will come across um, maybe they're close to one of the state lines of a state that we're in, and for whatever reason, it came up on an internet search or whatnot. We can help point you in the right direction, even if it's something that we can't handle. If we see a valid case, we've got some referral sources. So always happy to help, even if you're outside of one of those states.
Okay, cool. Today I'm going to ask this question. With the current situation in the government in terms of law is concerned, do you see this affecting um, what you do as an attorney?
No, federal government employees would be different. I don't handle any cases for federal government employees, but any private employees or employees of state or local governments, um, I don't see any impact. The federal government employees, yes, unfortunately, there's been some impact there, but The only thing I'd say about some of the DEI or anti-DEI initiatives, how it relates to private companies, is the EEOC. Anytime there's a new administration, the EEOC is going to change leadership, just like most government agencies. It's executive power of the president there. So they've named a new director, and that one of that director's initiatives is to say DEI programs are discriminatory. So we're going to try to find cases that are filed with our agency and attack companies that have aggressive DEI policies in their eyes that they say are discrimination, which it's going to be a double-edged sword for companies because I could see on one end people that are minorities arguing, well, now I'm being discriminated against because you don't have to follow your DEI program, but then on the other side, people are going to argue, well, I'm a white male and you said you had to hire a minority for that position. I think that's discrimination, which I think that's a good argument that it could be as well. So it's going to be a double-edged sword for companies that actually probably creates more work and more potential cases for the employee, for folks that do what I do. So yeah, that's opened up a whole another can of worms there. I believe that you're going to see a lot of cases fleshed out through the system, and the courts will ultimately decide on it.
Yeah.
And we'll see where it goes.
Yes, and I'd like to stay in touch, and we
Right.
definitely get together again and talk about just that piece of it. 'Cause
Right.
I'm
We'll see
sure
where
you're
that
going to be
goes.
getting busy with
For
that.
sure.
I'm
For
sure of
sure.
that. So again, Gary, how can people connect with you? This has been amazing. I've learned
Yeah.
so much. You've
Thank you so
actually
much.
I poured my situation out here as well.
That's right. That's right. It's so 888-415-7670. That's the line you call. We'll put you through our case evaluation process and then let you know if we can help from there.
Yes, yes, indeed. And I'll have all of that information in the show notes. So thank you so much, Gary, because employees need you, because people are always not treating each other right.
That's
It's,
right.
it's just it's just the way of the world, If you have any kind of power, then it's
Yeah.
like step on the little guy.
Yeah. That's biggest I guess reason why I love what I do. It's fighting for the little guy. It's not easy, but it's definitely rewarding. And yes, thanks so much, Ms. Crawford. I appreciate you having me. It's been unbelievable. And if you ever have any questions or any issues, just let me know. I'm happy to talk again.
Absolutely. Thank you. And thank you, audience, for tuning in. We appreciate you as well.
All right.